In the spirit of full disclosure, I must confess that I have a unique fascination with internet lawyers such as Stevens and the people who buy into their gibberish. The reason for this is that 40 years ago, I was one of them, before there was an internet. I led an association of about 5,000 members across 3 states. I gave seminars, sold books, VHS and cassette tapes, performed legal research, wrote briefs and motions, and represented members in court. I taught such issues as the right to travel versus driver's license, admiralty jurisdiction, income tax protest, fiat currency, ferns. It's all commerce, common law, posse comitatus, Article 1, Section 10, and other issues. Although I've been an attorney for decades, I can relate to and understand to some degree these internet lawyers of today. However, I feel a unique responsibility to point out the flaws in their interpretations and representations. These are a few of the books from back in the day. It amazes me that internet lawyers proudly claim they are uneducated in law and legal procedure, and people still listen to them in the 21st century. They take a word here, a sentence there, dicta from an unrelated case, and their interpretation of law, court decisions, and legal procedure, and weave them into a crazy quilt of legal gibberish. And the beauty of Stevens' crazy quilt is that when the gibberish fails, Stevens simply says, "See, it's not my fault. I told you they were all criminals." Many internet lawyers claim patriotism and rights protected by the Constitution as motivation for their course of action. Stevens' reason is decidedly different. Stevens, making an internet lawyer mistake, bases his legal course of action on his political philosophy, anarchy, or, as I like to call it, the philosophy of "you're not the boss of me." What is inconsistent, or just plain dishonest, is that Stevens states in his book, in the introduction on page 3, quote, "I personally have no political beliefs." Now keep that statement in mind, because he then proceeds to write 226 pages of his political beliefs about government and its political functions. Listen closely to Stevens. He constantly talks about the political philosophy of a voluntary society and the political writings of Lysander Spooner. Stevens challenges the power and legitimacy of government based on a political philosophical belief I call Spoonerism. Stevens, who claims no political beliefs, calls his latest book Government Indicted, based on his political philosophy. Obviously, Stevens has no idea what a political belief is. In addition, Stevens observes that government is just men and women. Duh, what an acute grasp of the obvious. He labels those who disagree with him, work in government, vote for government, or see value in government as indoctrinated, evil, dishonest killers, liars, and thieves. In other words, about 95% of the people. That's right, Stevens, 95%. However, this distaste for government and people didn't keep Stevens from moving to live in and use the developed resources and infrastructure of Arizona. Stevens and his family enjoy the benefits, freedom, safety, and tranquility provided by the jurisdictional power of Arizona, or wherever the hell Stevens thinks he is. In doing so, Stevens is giving informed, implied, passive, active, tacit, whatever the hell, take your pick, consent. And at the same time, from the comfort of his air-conditioned home in the desert, he broadcasts anti-American vile rhetoric, inferring that the laws of Arizona don't apply to him. Well, Mr. Stevens, the members, owners, citizens, whatever the hell you want to call them, of Arizona, chose majority rule as their political philosophy before you were born. You invaded their property or territory when you moved there instead of staying in New York. You made the choice of your own free will, and now you're giving Arizona the middle finger. Talk about being immoral and unethical. Stevens makes it very clear through his books, website, radio show, YouTube channel that his whole legal spiel is not only based on his personal opinions and beliefs, Spoonerism, but on the philosophical musings of Lysander Spooner as reflected in Spooner's book, No Treason, the Constitution of No Authority. It appears that Stevens has taken Spooner's philosophy as the gospel. That's why I call it Spoonerism. Stevens becomes very emotionally agitated and animated, like an evangelical when his beliefs are challenged. And if this isn't extreme enough, Stevens thinks he can make society, government, and law bend to his logic and his religion of philosophical Spoonerism. Now get this. In Spoonerism logic, law is illegal. Did you get that? In Spoonerism logic, law is illegal. Stevens believes those who disagree with his religiosity are criminal killers, liars, and thieves. In other words, sinners. That's just weird and creepy, if not dangerous to society. And Stevens wonders why his victims are being given psych evals when they chant his nonsense in court. Stevens likes to claim that he is not a sovereign citizen, but, like so many terms, I don't think he understands what that term means. Stevens goes into court, well, not him, but one of his victims, and they insinuate the Constitution and laws don't apply to them. In other words, they are not subject to the sovereign power of the government. Such a position infers that Stevens thinks he has sovereign power as a sovereign person, human, inhabitant, resident, dweller, or citizen, or whatever the hell Stevens wants to call himself. Stevens is so confused by his religiosity narrative, he doesn't even know what he is. Talk about the need for a psych eval. The rest of us can see through his confusion. Stevens has woven this religious philosophy, Spoonerism, into what he thinks is a legal strategy. The problem is, Stevens attempts to use this political philosophy, Spoonerism, as a basis of a legal position in court, and political issues are not justiciable. In this attempt, he tries to make law subject to his philosophical beliefs by misinterpreting basic law, court decisions, and legal procedure. He also cherry-picks definitions of terms to suit his narrative. I call Stevens an internet lawyer because his interpretations of law, court decisions, and legal procedure are based on his political opinions and religious beliefs, but have no basis in legal reality. And of course, like I said, courts cannot hear political issues. It's that separation of powers thingy. Now, this is Stevens' magic silver bullet Socratic question that he bases his legal Spoonerism bullshit and livelihood upon. Now, think for a moment of just how illogical that question is. Logically speaking, if the Constitution and laws did not apply to Stevens, he would have no power to say anything against the government, let alone have access to a court. More likely than not, prima facie, he would be sent directly to prison. No questions allowed. The very foundational question upon which Stevens' legal tactic is based is illogical and flawed. As proof, Stevens realizes his magic silver bullet applicability question is a political government issue. Here's a statement from him.
Quote is, so they don't give a damn about your political position.
And quotes from his book. Plus, he recognizes political terms. I tried for 6 months posting on Stevens' forum to enlighten him to the fact that he was presenting philosophical, not legal questions to the court. Did he listen? No. But alas, writing about political philosophy wouldn't generate enough revenue to pay the bills because, quite frankly, Stevens doesn't have an original thought on the subject. To generate the necessary revenue, Stevens must appeal to emotion to get his victims to act and challenge government at its lowest level. He then sells his beliefs and legal materials to his victims, such as repeat offenders, those who get traffic tickets, or other malefactors. By confusing a political issue with a legal one, Stevens thinks he has developed a system to control damage of bureaucrats. But without the willingness of his victims to challenge their violations, Stevens would starve. Stevens has convinced his victims they are ethically and morally fighting back for the good of mankind by showing how government is just a criminal enterprise, which, by the way, is another political belief. According to Stevens, politicians use their opinions and appeals to emotion to manipulate people to rob them. Well, Stevens applies the same tactics. Stevens gives false legal knowledge and hope to his victims in order to sell his bullshit misinterpretations, misrepresentations, misconceptions, and misinformation of law, court decisions, and legal procedure. I also notice Stevens uses word manipulations liberally. For instance, he confuses the terms legal determination and legal conclusion, a common internet lawyer mistake, or perhaps a deception. I'll cover his incorrect definitions as we go along. What do you think so far, Stevens?
Dirt, 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 dirt.
Bottom line is, Stevens would not have the right to criticize government, write books, talk bullshit on the radio, create YouTube videos, travel to 3 continents, etc., if someone at some time in the course of human action did not use violence to secure such rights and then back them up with power and force. Let's talk about this power and force. There are 2 basic types of jurisdiction that have evolved through the millennia of human action. They are power and the authority created by that power. The power jurisdiction, sometimes referred to as territorial jurisdiction, is vested in sovereignty of government. Now, without going into a long dissertation on the law of nations and the evolution of sovereignty, suffice it to say that in the United States, this sovereignty of government is vested in states and their subdivisions and the national or federal government. Territorial jurisdiction is the power of the government applied over a geographic area. This power, among other things, includes the authority to create laws, their enforcement, and courts. The evidence that this power applies to those within its territorial geographic area is force. There's your fact and evidence, Stevens. Call it what you want, but it's still reality, which is a requisite of a fact. It's the same force used by government to protect rights, like the ones Stevens enjoys and exercises. And yes, it's the same force by which government punishes people for violating laws. Without force, there would be no laws, only requests. This power is an extension of the sovereignty of government, which is a political, not legal issue. Stevens believes this power is criminal and illegitimate, but that is his political opinion. So, if the power of the government confers the authority to render judgment or decree to a court, then the court has jurisdiction. That's it. That's all that is required for a court to have jurisdiction. The authority conferred to it by the power of government. Period. No matter what Stevens claims. Therefore, contrary to what Stevens says, there is no appealable error or misconduct for lack of evidence of jurisdiction. The law is the evidence of the underlying jurisdictional power, and that's why judges take judicial notice that evidence of jurisdiction is produced when the law is produced. It's not a circular argument. It's reality. Sorry, Stevens, you're spreading another one of your internet lawyer misunderstandings. And remember that the government power and jurisdiction can only be challenged in the voting booth, not in court. Got that, Stevens?
Yeah, okay, yeah.
Stevens' internet lawyer opinion of what standard or form of evidence proves or does not prove jurisdiction is confusing. He uses the term prima facie, but clearly doesn't comprehend what that is. Likewise, he is confused about the prosecutor's burden of proof regarding jurisdiction. Typical internet lawyer mistakes.
And remember, we're asking a leading question. Is, I intend on pleading guilty. Has the prosecution met their prima facie burden? Is there any evidence proving the Constitution and Code apply just because I'm physically in Washington? The judge has an obligation to make sure that the prosecution has met their prima facie burden, to show that he does have jurisdiction to even hold you for the arraignment.
Stevens is correct that prima facie evidence is required to establish, prove, pretrial jurisdiction. And the required prima facie evidence includes things like statutes, case law, a certified complaint, or a traffic ticket with the cop's eyewitness statement on it. If any of these are produced, jurisdiction has been established, proven. Whether Stevens agrees or not, or if he objects claiming that's not evidence, his objection will be overruled.
Points that we're looking for here is evidence proving their claim that just because you're physically in Washington that the Constitution and Code apply. The other thing is we need to know if the witness they're calling has personal knowledge of evidence proving that the Constitution and Code apply. Because again, I have to keep repeating this, you have to have personal knowledge of the matters you're testifying to. If the police officer is making legal determinations that the laws apply and you violated them, which is why they're calling the cop, then he has to have personal knowledge of that. So that's what the two main things we're focusing on when we're talking with the prosecutor. And that is your opportunity to do some serious damage control, because you'll be able to get his own statements that he doesn't have the evidence, or he'll lie and say that the evidence is in the ticket.
Yeah.
And so you'll be able to use that against them.
So going into pre-trials, I'm just going to bring up all the evidence that I have against them. I'm not really sure how to go about fighting this in pre-trials. I keep pushing the issue. I'm going to keep pushing the issue of jurisdiction and prima facie, but other than that,
but that's what
should I
that's
prepare
what I'm
myself
saying.
with evidence and other things of the sort?
All you need to the only thing you need to show is bring maybe the ticket, because that's all they have against you. And so you can ask the prosecutor, where on this ticket or what on this ticket is evidence proving that just because I'm physically in Washington, your laws apply to me? What do you know, it's all written down. And so when it's that specific and it's something here that could be cited very easily, then he might turn around and say, I don't have to do that. And I would say, oh, excuse me, let me see if I understand you correctly. You can make a legal claim against me and you don't need any evidence. Really? And exactly what kind of relationship do you have with the judge you're allowed to get away with that?
Yeah.
And then you ask him, okay, so since you get to argue without evidence, you can make claims against me without evidence. Do I get to make claims against you without evidence?
Okay.
Okay, and then when he says absolutely not, I would definitely urge sanctions against you. Well, then why don't you? I said, do you think that's fair that you can make claims against me without evidence, but it's sanctionable against me if I do that? Do you think that's fair? And then say, why does it? Again, push. I like to do this. Say, what kind of relationship do you have with this judge where you can get away with that, but I can't?
Yeah. Okay.
See, and this is how the pretrial should be. You should be pounding away.
Well, kind of gets excited, doesn't he? Well, there's a lot to unpack in that rant. As you've heard, Stephen goes into full internet lawyer mode, displaying his misinterpretations and misconceptions and baseless allegations of lying. First, personal knowledge of the cop. Stevens must love to get this wrong because he does so often. Stevens' internet lawyer misinterpretations of Rule 602 is typical of him. He totally ignores the second sentence. The cop's eyewitness testimony is all he has to provide for the purposes of arraignment. Stevens seems to think more is needed for prima facie evidence. I doubt that the cop's eyewitness direct knowledge testimony about the ticket would contain any exculpatory evidence. Then Stevens talks like he's at a pretrial hearing or conference with the prosecutor asking questions. He mentions the cop making a legal determination that the law applies. Well, that's true. A cop, like any witness, makes a legal determination that the law applies. A legal determination is not final and is simply deciding based on the limits of knowledge and belief held at the time. Any witness to a crime can make a legal determination based on their personal knowledge and beliefs that a law has been violated. For example, let's say you see what you think is a crime in progress. You pull your personal concealed weapon and hold the perp at gunpoint until a cop arrives. You would never have to prove that the law applies to the perp, and neither would the cop. That's where Stevens misrepresents the facts. The question of applicability of law requires a legal conclusion. Otherwise, it would be a political question about the government's power, as I've previously explained. No witness can make a legal conclusion, only the judge. A legal conclusion is final and means that all the evidence has been presented, and the judge concludes, based on the evidence and relevant law, which party has met their burden. Simple, huh? Well, except when Stevens applies his gibberish. I will explain this subject more fully in future videos. Secondly, the ticket. The ticket is prima facie evidence of an alleged violation of law with eyewitness testimony about facts of time, place, conditions, and activity. Third, notice how Stevens loses control, hurling accusatory questions, inferring misconduct, and lying. Typical internet lawyer mistakes. Fourth, sanctions. What the hell is he talking about? It's complete gibberish. No sanctions, just dismissal of the case. And it's not advisable to become so confrontational in a pretrial conference. If it's carried over into court, it could result in a contempt charge unnecessarily. Another internet lawyer mistake. Let's talk about evidence. The foundation of Stevens' legal tactics is his belief that there is no evidence that a prosecutor or judge can produce that proves the Constitution and laws apply to anyone without consent. After all, according to Stevens' Spoonerism, the people who agreed to and signed the Constitution are all long dead. Therefore, it cannot apply to those now living. This is a political, not a legal issue. Another internet lawyer mistake by Stevens. Stevens asks in his videos and in court, has the prosecutor met his prima facie burden of proof that jurisdiction exists? When the answer is yes, Stevens and his victims go apoplectic. This is where their legal ignorance first appears in court. Here's the real deal. Stevens' magical Marcratic question, has the prosecutor presented any evidence that proves the laws apply just because someone is physically in a certain geographical area, is incomplete when used in court. For the question to be valid in a legal proceeding, it should be, has the prosecutor presented any admissible evidence that the laws apply, blah, blah, blah. Why? Because in court, admissible is the standard and requirement of evidence. Instead, Stevens cherry picks a definition and standard of evidence that fits his narrative and beliefs. Let's see what the definition of evidence is. These are the definitions of evidence that are relevant and used in court. Take note of the terms information, testimony, documents. Stevens is given such evidence of jurisdiction, but rejects it because his belief in Spoonerism does not allow it. The fact and reality that people have the law applied to them and the factual evidence that they are punished escapes Stevens' Spoonerism logic. He denies these facts are evidence, according to Spoonerism. Now, who needs a psych eval? Someone who can't face or accept the realities of modern society. Evidence comes in four basic forms: demonstrative, documentary, real, and testimonial. Some rules of evidence apply to all four types, and some rules apply to one or two of them. All these forms of evidence must be admissible. Therefore, Stevens' claim of prosecutorial or judicial misconduct because the prosecutor is arguing or bringing a case without evidence is pure and total bullshit. Another typical internet lawyer mistake. You got that, Stevens?
Yeah, okay, yeah.
Now, back to Stevens' question about prima facie evidence of jurisdiction and the prosecutor's burden of proof. If you notice on the slide, Stevens would be required at trial to produce evidence that the laws don't apply, to refute the prima facie evidence. Guess what? He can't. That's why he doesn't want to go to trial. Now, prima facie is a very low standard with a low burden of proof. Depending on the particular threshold issue's importance, prima facie might mean any of the standards below the more than likely than not standard, namely the slightest possibility, reasonable possibility, substantial possibility, or equipoise. In other words, there is the slightest possibility that there is jurisdiction and the allegations are true. I'll say it again. Prima facie evidence is all that is required to establish, prove jurisdiction at arraignment. And this prima facie evidence includes things like statutes, case law, a certified complaint, or a traffic ticket with the cop's eyewitness statement on it. If any of these are produced, jurisdiction has been established and proven. Whether Stevens agrees or not, or if he objects claiming that's not evidence, it does not matter. His objections will be overruled. Now, it's essential that Stevens ignore the definitions by authoritative sources and what constitutes admissible evidence in court. It's important that he substitute his opinion of what evidence is. Without this substitution, Stevens' assertion of lack of evidence to prove applicability of law falls apart. And it does fall apart, especially in court. Courts reject Stevens cherry-picking the definition of evidence to fit his religiosity philosophical narrative, and instead they use the rules of evidence. Furthermore, without Stevens teaching his people his definition of evidence, he wouldn't be able to sell his bullshit legal interpretations. But wait, there's more. Stevens then takes his misinterpretations of evidence and tries to convince his victims to file motions that assert the judge and or prosecutor are guilty of willful misconduct by conducting a trial without Stevens' interpretation of evidence. Talk about being misleading and dishonest. Talk about making his victims look foolish. You're not a fool, are you? Now, what's inconsistent is Stevens is always demanding evidence, yet all Stevens has is faith, meaning evidence not seen or things hoped for. He believes in the words written on paper by a man, Lysander Spooner, over 100 years ago, which Stevens worships. Stevens does not have first-hand personal knowledge that a society without government would function as long, as consistent, and as domestically tranquil with 300 plus million people. Period. Ain't that right, Stevens?
Yeah, okay, yeah.
Stay tuned for future videos where I further debunk Stevens' dishonest deceptions and bullshit legal tactics. Topics will include the Socratic method, informed plea, asking the judge questions, objection, point of clarification, discovery, Brady request, cross-examination, competent witness, misconduct, bias, definitions, inconsistencies, and actual cases involving Stevens' bullshit motions. Now here's a teaser. Stevens is wrong when he claims that jurisdiction is an element of a crime. Are you ready, Stevens?
Yeah, okay, yeah.
Go home, folks.